Now let's consider Section 77 of Indian Penal Code. It's about the act of a judge acting judicially. For fearlessness and independence of administration of justice, special protection regarding their official acts and conduct of judges is absolutely necessary. The role of judges and those engaged in performing judicial functions requires this kind of protection. A judge generally punishes either an offense or vindicates the rights of a private individual. And if he were hampered by fear of consequences which might arise from a mistaken conclusion, he could not have that independence of mind which is essential to the discharge of his functions as a judge. This is the rationale behind exemption of judges from liability. This section and Section 78 of the IPC give protection to judges on the criminal side, whereas Judicial Officers Protection Act exempts judicial officers from civil liability. To maintain an independent judiciary in all democratic countries of the world, protection is offered to judges by securing them immunity from civil liability and criminal protection, and also affording them security of tenure. The text of the section reads like this: Nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is, or which in good faith he believes to be, given to him by law. For a judge to avail the benefit of this section, these are the requirements. The act must have been done by a judge in discharge of his official duty. Secondly, the act must have been performed within his jurisdiction. And thirdly, it should be done in good faith. The scope of immunity in this section is very wide. Even if a judge exceeds the jurisdiction granted to him by law and prosecutes a man for committing the offense, still a judge is protected under this section. But the important thing is that the act should have been done in good faith and under the official transaction. Allahabad High Court, in a case of Meghraj versus Zakir Hussain, reported in ILR 1975-1 Allahabad 280, went on to the extent of saying like this: No person acting judicially is liable for an act done or ordered to be done in the discharge of his official duty within the limits of his jurisdiction. In such a case, the question whether he acted in good faith does not arise. So, for example, if a magistrate, on an erroneous reading of law, assumes that he had the jurisdiction to decide a particular case, still he is not criminally liable for exceeding his jurisdiction, although he had no authority to conduct the case. But then this would not apply when a judge knowingly exceeds his authority or does something contrary to law. Now let's go to section 78. It is about act done pursuant to the judgment or order of court. Nothing which is done in pursuance of or which is warranted by the judgment or order of a court of justice, if done whilst such judgment or order remains in force, is an offense, notwithstanding the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had such jurisdiction. Previous section 77 spoke about the judge himself. This section speaks about the person who acts in pursuance of the judgment. Therefore, we can say that this section goes one step further. This section grants immunity to officers acting in pursuance of a judgment or direction issued under the order of a court of law. Example: sentence of whipping has been abolished by Abolition of Whipping Act 1955. Now suppose if a magistrate issues a direction to a jailer to carry out the sentence of whipping, and if the jailer executes that sentence upon the convict under the direction of the magistrate, then even if the order of the court is illegal, the jailer is not liable for executing an illegal order. This is because the jailer's act was an act done in pursuance of the order of a court, and therefore he will be protected under this section. An officer is protected under this section if these two conditions are satisfied. Firstly, that the action of the officer should have been done in good faith, and secondly, he should have believed in the legality of the order. If these conditions are satisfied, the officer will not be liable for prosecution, even if the court issuing the order had no jurisdiction, or that the order happened to be